the observations that are being shared by Justice Sharma over there. Remember, the pronouncement of the verdict is currently underway. In fact, the court is reading findings on the arguments regarding validity of the statements of the approvers and statements recorded under Section 50. Let's quickly go to Anshul on that aspect. Anshul, the validity of those statements exactly some time ago is what we were discussing, Anshul, the validity of how crucial is it in terms of accepting this as admissible evidence when it comes to statements of the approvers, because PMLA gives you that leeway to account or factor in those statements as evidence.
So yes, a very important observation that has come out in the judgment from the side of Sankanta Sharma, Justice Sankanta Sharma, where she has said that material collected by the Enforcement Directorate reveals that Mr Arvind Kejriwal conspired with others. The ED case also reveals that he was involved in personal capacity as well as the convener of the Aam Aadmi Party. So yes, definitely a very, very big setback, it seems, as the observation has come out, that the court also feels that the material, after looking at the material that the Enforcement Directorate has provided to the court, the material that the Enforcement Directorate has, the evidence that the Enforcement Directorate has, actually reveals that the Delhi Chief Minister actually conspired with others in this entire matter, and the Enforcement Directorate has also told the court, and the court has also observed this in its observation, that he was not only involved in personal capacity but also as the convener of the Aam Aadmi Party. Now the court is also narrating.
There's another interesting observation coming in, Anshul, which is with regards to casting aspersions on the validity of the statements of the approver. In fact, granting pardon to approver is not under ED's domain and is a judicial process. That is what the Delhi High Court in its verdict is also making as an observation. If you cast aspersions on the process of pardon, you're casting aspersions on the judge. That's what the court has had to say. Please break it down for us.
So yes, if you see, this was the argument that was put forth by Abhishek Manu Singhi, where he had claimed that people like Manguta Reddy, who have turned approver, have been pardoned, and people like Samir Mahindru, who have turned approver and given their statements to the Enforcement Directorate, they have actually been pardoned. To that, the court says that the giving a pardon or allowing someone to turn an approver is not the purview of the Enforcement Directorate, is the purview of the court. And if you are casting aspersions on the manner in which that person has been allowed to turn an approver and has been pardoned, then you are actually raising aspersions on the court itself, which is definitely not very necessary, is what the court feels. Now the court has also gone ahead and said, as being reported by Ananya Bhatnagar, who is inside the courtroom at this point, the court says that the law of approver is a very, very old law, and when in existence before law, the birth of many of us, including one writing this judgment, had not happened, which means that the court says that this is a set precedence of how a person turns approver and how a person gets pardoned in this entire matter, and this law has been followed for a very, very long time. There are precedents from a very, very long time till the time that the people who are arguing this case or even the judge was born. Even from before that, this law has been in place, and that is how people are being turning approvers, and they have been allowed to get pardoned.
Another very crucial observation that has come in from Justice Sharma is the fact that the material collected by the ED has gone on to reveal that Mr Kejriwal did conspire with others, and that in fact heavily sort of dents the kind of argument we had seen Abhishek Manu Singhi make in front of the court, where he said that there is no concrete evidence on record which merits or necessitates this arrest.
Well, definitely, the court also feels that the Enforcement Directorate has that material that actually proves that Arvind Kejriwal had conspired with others, not only in individual capacity but also as the convener of the Aam Aadmi Party. So definitely a big setback for the Delhi Chief Minister, as now the court has given it in its observation, and definitely the legal team of Arvind Kejriwal, of the Delhi Chief Minister, has a lot on their plate as to think about, as to how they can actually go ahead and challenge this verdict, which actually says that he was involved not only in individual capacity but involved as the convener of the Aam Aadmi Party, and benefits of and the profits of crime was actually given to the Aam Aadmi Party. And since he was the convener, he has that vicarious responsibility to actually be prosecuted is what the Enforcement Directorate had already told the court, and that is what has also been said by the court in its order. As we speak, the judgment is still being read out, and on the issue of non-supply of documents, the court has said that the accused will be entitled, as per the law, whatever documents they need as per the law, that documents would be provided to them, because remember, the Enforcement Directorate is keeping its cards very close to its chest, because at this point in time where the investigation is, they do not want to reveal about the nitty-gritties of this entire matter, and that is the reason why a few of the documents that were asked by the legal team of Aam Aadmi Party, those documents were not given. To that, the court has said that documents would be provided to them. Whatever documents is required to them as per the law, not the entire case file would be given to them. Because remember, once the court had asked the Enforcement Directorate to actually provide them with the material of the case, what evidences do they have in this entire matter, that was given to the court in a closed envelope, and after reading that only, Arvind Kejriwal was actually sent to jail.
Another important observation coming in is that the court is saying that whether MS Reddy or Sharath Reddy gave false statements, Mr Kejriwal would have the right to question the same and would cross-examine them during the appropriate stage. So the court clearly dichotomizing the investigation from the trial stage over there.
Well, definitely, as we have been telling our viewers, that at this point in time, the entire case is at its nascent investigation stages. The arguments on the charges, the arguments on the evidences will happen at a later stage, when eventually the investigation will come to an end, and post that the trial will happen on this entire matter. At this point, the arguments are not happening on the validity of the case. The arguments are happening on the arrest of the Delhi Chief Minister. So yes, that is what the court has told the counsel of Arvind Kejriwal, where they have said even if the statements of the approvers are false, that could be ascertained at a later stage when the trials start in this entire matter, and Arvind Kejriwal and his legal team would be given an option to prove that in front of the courts, that these statements that have been made by Manguta Reddy and his son Raghav Reddy are actually false and motivated. Because remember, the argument that was put forth from the side of Abhishek Manu Singhvi, that it was only after they were allowed to turn approvers in this entire matter, their statements were taken on record and were presented in front of the court. Before that, there were 7 to 8 times that the statements were recorded, and this is what the Aam Aadmi Party has also been claiming, that the approver statements were recorded at least 7 to 8 times, where they did not take the name of Arvind Kejriwal, and the court has now made it clear that at this juncture we are not arguing that if at all those statements are true, those statements are false. We are not arguing if the evidences that the Enforcement Directorate has, those evidences are sufficient or not. At this point, what we are arguing is the